Hello everyone, welcome to Court with Krissy. This is the first time I've caught a hearing with this case, but believe me, after watching this, I'm on the lookout for updates. This pro se landlord must really like losing. I think you'll like it. Court with Krissy is now in session.
And do we have Mr. Bradley?
Yep.
Yes.
All right, there you are, Mr. Bradley. Mr. Bradley, did you turn your audio on so I can hear you?
Yes.
Okay, all right. All right, so let me kind of get the pleadings in front of me here.
Did you read my complaint or summons and complaint and everything?
Well, hold on, there's a lot of documents. I want to just,
Yeah, I know.
all right.
And I'm doing this pro se, so I mean, I don't know.
Okay, well, let me just kind of review what I believe is on our plates today.
They say Benjamin Summer wants to have it dismissed, but I don't.
Okay, hang on, Mr. Bradley. Okay, so this matter was noted on by the defendants represented by Mr. Summers for today's date for their response to Mr. Bradley's motion to strike untimely and inconsistent defenses, and secondarily for the defendant's motions for sanction. And so I did read there were some pleadings, and Mr. Bradley, you've received those.
Yes.
All right, so let's want to locate the Mr. Bradley's motion to strike.
Yes, Your Honor. I believe that was filed 2 or 3 weeks ago now.
Yeah, right. I've got it.
Okay.
Okay, so a lot of information. This has been a pretty active and busy case.
Yeah.
So I did read Mr. Bradley's. I'm not sure if I did them in the order that I think we should take these now, which is Mr. Bradley begins by filing motions to strike and explains his argument in his pleading, and then Mr. Summers responds to that and requests sanctions. So let's just start with Mr. Bradley. Anything I've read your pleadings, Mr. Bradley, but I'll just turn to you, and why don't you tell me anything that you'd like to about this?
Well, basically it should start back to May 31st when he lied to the court and said he had a court order. And he didn't have a court order, and he got a continuance for 2 weeks. They didn't answer the summons and complaint by the deadline. You can read my summons and complaint. And I served it, on May 10th, and I gave him until May 19th to answer, and he didn't get a court order until,
Let's just stop there for a minute, because I know this has been discussed several times, but on that point, my recollection is that Judge Basher heard your motions, heard your arguments about that, set a deadline requiring an answer in writing, and that Mr. Summers then provided a written answer by that deadline. So let's just that'll be the starting point. Isn't that what happened, Mr. Bradley?
yeah, but he turned around and ordered him because Benjamin Summers has been delaying this, postponing it, and, you know, bringing other things into the hearings, and it wasn't a merit on the case, them paying rent.
Okay, so you agree that just in terms of the chronology here, you had been essentially arguing that they had not provided a written answer. You demanded a written answer. The court agreed with you and set a time for that written answer to be provided, and Mr. Summers complied with that.
Well, it took him 8 months. I mean, that's way
Okay.
out of the line of
And the
complaint.
Summers-
If you read summons and complaint, it says in there, it has all the statutory things that they're, you know, supposed to get an attorney and all that. And it said, has a date that they were supposed to answer by. And 8 months later, then they turn around and answer. He was ordered twice from the court that he needed to have a written answer presented to the court, and it took him until January 9th.
Okay, and I understand that you don't like that and you disagreed with it, but what I'm trying to focus in on, just to make sure we're all on the same page, that ultimately the court, and I believe it was Judge Basher, agreed with you that and required him, that is Mr. Summers, the representing the defendants in this case, to provide a written answer, and Judge Basher gave him a deadline in which to do that. And even though that was sort of late in your opinion, he did provide that written answer by that deadline.
Yeah, but the answer was inefficient. It was nothing to do with the rent, you know.
Okay. I'm just talking about the timing, though. He complied with Judge Basher's order to provide a written answer by a date certain, and he did that, correct?
Yeah.
Okay. Mr. Summers, do I have that right?
Yes. Excuse me, Your Honor.
But he was wasting the court's
Mr.
time.
Bradley,
Didn't answer.
excuse me, Your Honor. But yeah, that is about the long and short of it. Yes.
Okay. And so Mr. Bradley, I think we've covered the timing aspect of it, and I very clearly understand that you felt that it was unfair for so much time to elapse before you finally got an answer. So we're sort of past that. I know it's been covered at several hearings. So now
It's supposed to be strictly construed. And
let's turn then to your other requests. Aside from the timing, you're moving to strike inconsistent defenses.
yeah.
And again, you typed up your motion and included an argument. So go ahead and let's talk about that now.
Okay.
Go ahead, Mr. Bradley. What would you like to tell me?
Well, it's everything it says right there in my
And that's fine. You don't have to, is there anything in addition to what you wrote that you would like to? That you would like to argue? I mean, you have an opportunity to make an argument both in writing, which you did, and sort of in person or orally, which I'm giving you the chance to do now if you would like.
Well, basically it says everything in my complaint. I was just basically, he wants it, just he wants it to be dismissed and everything. And I don't think it's proper.
Okay. All right. Let me turn to Mr. Summers. Mr. Summers, what would you like to say again before we get to your motion for sanctions, but your response to Mr. Bradley's motion to strike as being both untimely and presenting inconsistent defenses?
Yes, Your Honor. Again, I believe most of what I said most of what I had to say on that is reflected in my briefing. I do not believe Mr. Bradley has grounds for that. Again, like Mr. Bradley, his argument appears to be based on a keen misunderstanding of the court's previous rulings, as well as several cases which, to date, I have not been able to identify. I believe Loy v. City of Seattle, that's one that I noticed. I was unable to find that via Westlaw. I was unable to find that via any other means. I do not know where Mr. Bradley found that case. Additionally, I think that Mr. Bradley is essentially arguing here that because he wants this, it should be given to him. I don't believe he is providing any proper evidence of that. And ultimately, I believe that Mr. Bradley's motion should be denied.
I'm just trying to flesh this out. What are the inconsistent defenses, Mr. Bradley? I mean, how are the defenses that he's indicated in his answer, how are they inconsistent?
Well, he was supposed to answer on I way back with Scudder, and he was supposed to have a written answer to the court on the merits of the case. And basically, he comes to court and he files an affidavit from Holly Henson, that I'm doing forgery and I'm, embezzling and, all this stuff, when I own the property and I'm not embezzling and I'm not forging nobody's name. And basically he's bringing up stuff that don't need to be brought up.
Okay.
You see, it's, they don't pay rent. They haven't paid rent for 18 months. They owe $24,000. And Benjamin Summers has been delaying it and saying all kinds of different stuff, to get the court to believe I'm embezzling and I'm doing forgery. And I'm surprised he hasn't, bring up my background history, that like he already threatened me he was going to do, that I have an email, and I'll let the court know about your past history. And that was over 20 years ago. I'm not even the same person. So, he's bringing up stuff. Basically, they don't pay rent. They haven't paid rent since April of 2023. And I just basically, they need to move out and give me my property back to me. They're sitting there they're destroying the house. They bust into the windows. And I'm just basically, I want my writ of restitution granted. I've served them the summons to complaint. It says I will not accept cash. They keep saying that they paid me, and I can't even accept cash in the unlawful detainer. So where they don't, he doesn't show no proof of payment. And it says in my summons to complaint, I will not accept cash. It has to be a check or a money order, or they need to put it in a registry. And they don't show no facts of any of it. I don't have to prove that they paid rent. They need to prove it.
Okay. Mr. Summers, with respect to this issue of inconsistent defenses, if you help me out here, because I believe that in your answer, and I haven't reviewed it really recently, but you're alleging a breach of implied warranty of habitability defense. Is that right?
Yes, Your Honor. We brought a implied warranty of habitability defense. We also dispute the claims of non-payment. We argue that Mr. Bradley has not met his burden of proof for showing that my clients have failed to pay.
Right, and at least on that point, that sounds like, I mean, that having asserted those two defenses, that's why the court has previously ruled there are material issues of fact, which then requires it to be set for trial. And my understanding is you already have a date. The next forward date is for the universal readiness docket.
Yes, Your Honor. That is currently set for March 18th.
Okay. And if I remember correctly, it had previously been set for trial with the prerequisite readiness hearing docket. And that was sort of postponed due to filings of some additional motions. Is that right?
Yes, Your Honor.
Right.
That is something I can address further in my motions for sanctions.
Okay. All right. Okay.
How could I be sanctioned for?
Well, you haven't been sanctioned yet, Mr. Bradley. So hang on. I'm trying to approach this from start to finish here. And the starting point is your motion to strike defendants' untimely and inconsistent defenses. So I've read your memorandum that you put together. I've given you the opportunity to address the court. I've heard from Mr. Summers on that.
But he's answered twice. I mean, how many times did he get a chance of answering when?
Okay, well,
and the habitability, I didn't get no notice. There was nothing.
okay. Well, like I tried to explain, the court has already ruled.
They ruled wrong.
Mr. Bradley, hang on, Mr. Bradley. The court's already ruled on the timeliness. That is that Judge Basher gave him a date certain to provide a written answer, and he
has two different answers. It's not.
Mr. Summers, two different answers. Help me out with that. I'm not really following that.
I'm lost too, Your Honor. I've only filed one answer in this case. I don't know if Mr. Bradley is referring to some other filing. I'm in the same boat as you are.
You orally when Summers or Mr. Scudder asks you to file an answer on the merits of the case, paying rent and everything, and you come with an affidavit from Holly Henson. That's not an answer.
Is that referring to isn't there another action going on along the lines of
Yeah, that Benjamin Summers.
Yes, Your Honor.
Okay. Go ahead.
property.
I can shed a little bit of light on that. We did file an affidavit of Holly Henson. She's the attorney of record in a matter for a quiet title action that's been brought against Mr. Bradley. We did file that some time ago, and I believe that I did bring that and raise an oral motion with the court to push out the hearing, like kind of to find out what the results of that were. The court did deny that, and we have not proceeded on anything regarding that since. I can't speak for the status of that particular action as I'm not the attorney of record on it.
Okay.
Yeah, you're in hoots with her because you're talking with her because if it all comes down and have somebody do the investigation, you will be hooked up with Holly Hansen trying to get me to where I didn't own the property. That's what you've been doing through this whole court procedures, saying that I don't.
Okay, Bradley, hang on. I'm just trying to understand. In the big picture here, there's a lot going on, and I'm trying to understand when you maintain that, as you said, as you have argued, that he's provided two different answers, and he says no, he's only provided one answer. I'm wondering if your assertion that he's provided two different answers has to do with this
Unorally,
of
and then he just got ordered to file an answer.
Okay. All right. So here's my ruling on Mr. Bradley's motion to strike the defendant's answer as both being, number one, untimely, and number two, presenting inconsistent defenses. As to the untimeliness, it's not untimely. His answer was the judge. Hang on, Mr. Bradley, I'm ruling now, so I've given you every opportunity I can to address the court, and now I have to give you my ruling. So with respect to the untimeliness, that is not a basis to grant your motion to strike his answer. The court has already ruled that his answer was within the time frame that the court demanded. And you agreed when I first started this, I was trying to pin this down, and you were in agreement, even though you don't like it or you disagree with it.
I didn't have a choice.
Agreement that Mr. Summers' answer was within the time frame that the judge demanded he file that answer. So on that basis, I'm denying your motion to strike. And now I'll address the second issue that you raised, which was inconsistent defenses. On that, from everything that I've read and heard here, the defenses aren't inconsistent. A party can have more than one defense, and as Mr. Summers, as I understand Mr. Summers's position, one defense is breaching the implied warranty of habitability. Two, he's really challenging your burden of showing that rent was not paid. I don't think those are at all inconsistent. They're two separate issues. An issue about whether there was a breach of his contractual duty to pay the rent because of their claim that the premises were inhabitable. And second, that you haven't shown, and you'll have the opportunity at a trial to show, that's what the trial is about, that they did pay. So I don't think there's anything at all inconsistent about those two positions. I think one is a defense and the other is sort of characterized as a defense, but really it's saying, hey, you haven't shown what you have to show with respect to non-payment of rent. So,
But I don't have to prove it. They do. They have to, it says in my summons and complaint, they haven't paid rent for 18 months. And they keep saying that they've been paying rent and they haven't. So I would rather not have this dismissed and let's all go to trial then.
well, right, and it is set for trial.
Okay, all right.
You as the plaintiff do have a burden of proving by a preponderance of the evidence certain things, and they can make an argument that you have not done so. And that's really what I'm referring to with respect to this defense.
But I did answer their summonsing or their answer. I answered. I gave him all of the paper, everything that I had.
Okay.
I answered him and I served it to him. And I served it to the court too. He's saying that I didn't provide inventory, all this other stuff that I shouldn't have to. They haven't even showed anything about rent.
Okay, and that's trial, Mr. Bradley, that's what the trial's about.
Okay, all right.
So, all right, now we're moving on to the next issue and the final issue, which is Mr. Summers's motion for sanctions. So, Mr. Summers, this is your motion. You get to go first.
Thank you, Your Honor. Okay, so CR 11, basically CR 11A specifically, it lays out the kind of specific minimal standards for filing of pleadings, briefings, or legal memorandums in the state of Washington. The idea is, it kind of prevents baseless filings and abuses of the legal system. Per In re recall of Lindquist, which I did cite to in my briefing, these sanctions, they are available against pro se litigants, pretty much the same as they are against attorneys. Basically, if you file these, if you do these even as a pro se in Washington, you are effectively putting yourself under the same sort of umbrella as lawyers are when they do so. Your Honor, Mr. Bradley has repeatedly made filings that run well afoul of Rule 11. Basically, these filings are supposed to be well grounded in fact. He consistently fails to present any real argument for his motion that are not either based on just ignoring previous decisions that were passed down by the court, as you've seen earlier, or by just misrepresentation of our arguments and evidence. These are supposed to be available under, what he's asking for, it needs to be available under established law or good faith argument for the change of the existing law. Mr. Bradley has, with his most recent motion, he has brought this by way of just critically misreading existing law and referring to case law of very dubious origin. Again, I believe there was the case that I mentioned to you earlier. I believe there's at least one other case on his briefing that I was unable to track down. In the process of that, he's pretty much just ignoring the existing black letter law, and he's ignoring any real proceedings that these courts have set up in order to show kind of how you can make arguments against that existing law. These need to be brought when he's bringing motions, they can't be interposed for any improper purpose, such as causing unnecessary delay. Mr. Bradley has regularly engaged in a practice where the case will be set for a trial. He will bring some brand new motion arguing that against some element of our case, arguing for it to be thrown out for one reason or another, and why he should be granted the writ of restitution and a judgment. And Your Honor, at a certain point, it just become a pattern like this. It becomes very evident that Mr. Bradley is purely doing this for the purpose of just trying to delay a trial that he doesn't like his chances in. He's simply bringing this because he knows that if this goes to trial, it might go either way. He doesn't know. So he's basically just bringing these completely baseless motions with the hope of just kind of pushing it out a little bit further or potentially getting a little edge for himself. Finally, like denials of factual contentions, those need to be warranted on the evidence. Mr. Bradley repeatedly fails to show any genuine dispute of material fact between his allegations and the arguments that we've provided so far. He has not shown any additional evidence that might tip the scale towards his arguments. Again, Your Honor, this is a repeated pattern of just him effectively finding a molehill and presenting it before the court as a mountain. Like this has been a repeated issue in this matter. Again, I have like the last three briefings I have filed in this case, they have addressed these issues with Mr. Bradley's four most recent briefings, because I believe that the one I filed back on February 7th, for the hearing on February 7th, I didn't file it at that time. That did address two motions that Mr. Bradley had filed, both of which I believe fall well into the category of what CR 11 says that shouldn't be happening in these courts. Again, Your Honor, I think that this is just a repeated pattern of bad behavior. I believe that Mr. Bradley has been warned in the past about this.
Bad behavior?
At this point, Your Honor, I don't know what else can be done except for bringing sanctions against Mr. Bradley. The sanctions that are available under Rule 11, again, the courts have held that that the court does have broad discretion with that. Under that, I would ask that this case be dismissed and that attorney's fees be awarded.
I disagree. Sorry. I mean, because I'm doing it pro se. I mean, I might have screwed up on some of the Archie, whatever, and everything, but we just got an answer on January 9th. And here I've been trying to file, I didn't know what I was arguing about against, because he keeps coming up with all kinds of different stuff that, it's just, I don't know what their argument is, because it's always different every time he filed, or he wants to be sanctioned. He tried, filing, that I shouldn't be able to file anything against them. And God, he's wanted the Judge Baxter said that he was wasting the court's time by not answering the summonses and complaint. I filed it twice on the 31st. Nobody wants to go back there when he lied to the court to get a personal representative for their attorney. When he didn't answer the summons and complaint by the deadline, and here now he's wants it dismissed. I just, if we went back to the 31st when he lied to the court, said he had a court order when he didn't, I would have had the writ of restitution granted to me. And that even Judge Baxter said he doesn't know why they didn't order the writ for me. So, and he said that in that court hearing, when he yelled at Mr. Summers and told him he needed to answer by the next day, he turned around and filed it electronically, and you're not supposed to. So, I mean, and then none of his documents.
Your Honor, I would object to the characterization of that. My clients did bring that into the office and and filed the copy with the court. Mr. Bradley did receive a copy electronically, and
Yeah,
I do.
but I didn't get it until the next Tuesday after Friday. I was supposed to get it that day too, but I didn't get it. You were supposed to service both
Okay.
and me.
Well, that's fine, Mr. Bradley. I think I've got enough information to give you both a ruling on this. So one thing, Mr. Summers, this was on for your response to his motion to strike, and secondarily your motion for, and then it seems to me you've added in, am I missing something?
Ability.
You're moving to dismiss. That wasn't part of your pleadings though, was it?
Your Honor, that was contained in my briefing.
Well, I deny the motion to I mean, it's not in the caption. It might be in your briefing. There's a lot of information there, but the court had previously, after, many hearings and
Delays.
there's been quite a long chain of steps in the litigation in this case, and my understanding is that it's been set for trial, or a trial date will be chosen. So I'm going to deny your motion to dismiss the matter in light of the fact that the court has previously found that there were material issues of fact that require a trial instead of a summary proceeding. So I'm not going to grant that. With respect to your motion for sanctions, I'm not going to grant that. I mean, I understand there's a lot of frustration by both the plaintiff and the defendants in this case. And even though I acknowledge that a pro se litigant is held to the same standard that an attorney is, and some of the steps that Mr. Bradley has taken might not have been taken by an attorney, but having heard him at least on 2 dockets now and having reviewed his pleadings, I guess I don't think he's proceeding in bad faith. Mr. Summers disagrees with him. But over the course of the litigation, Judge Basher did agree with him with respect to the requirement of an answer. And I think he had his position was well taken with respect to these particular motions, the motion to strike as being untimely and presenting inconsistent defenses. I don't think that that's being done in bad faith, and I have to provide some leeway for a pro se litigant. So
Thank you.
And also as an aside, this isn't a situation where a client has retained an attorney who's incurring costs because of sort of vexatious litigation. That's not the situation where Northwest Justice, Tacoma Pro Bono community lawyers are being, their services are being provided. So, and that's an aside. But I decline to impose any sanctions against Mr. Bradley. I mean, I think we've done quite a bit on this case. The case is almost at trial. I'm not seeing much room for any further motions to be made really by either side.
Well, Your Honor, I wanted to let you know that I did serve a 90-day notice.
Hang on.
And I served it way back. So I did serve that to where they need to be out. They needed to be out by March 5th, but they're not. So now I got to file a summons. I gave them a summons and complaint, and now I got to give them 4 or 7 days or something like that, and to answer. So he's going to argue whatever, and they haven't moved out. And so I'm going to file that in probably another 7 days, because I just served him last night the papers on the 90 days, because I've already served them and he already knows that they got it. So,
Well, that's not in front of the court at this time.
yes, I know.
So what's going to happen with that?
I
But
don't.
it doesn't, just listen to me for a minute, Mr. Bradley. That doesn't change my ruling that the defense motion for sanctions is denied. I mean, it's discretionary. I'm not seeing bad faith. Mr. Bradley is pro se, and based upon his the fact that the court disagrees with his position, I don't think, given that he's pro se, doesn't warrant sanctions. So those are the issues that were on the agenda for today. Summers, do you disagree with that, or is there anything else? Am I missing anything?
I don't believe there's anything further I can argue at this time, Your Honor.
Okay, so I think what I'll do is just I'll prepare a bench order and have that into the file with respect to denying Mr. Bradley's motions and denying your motions for sanctions. And as far as I can tell, you've already been given dates.
Yeah.
We have, Your Honor.
Okay.
Hang on one thing.
Sorry.
Go ahead.
Mr. Bradley's motion was set for next Friday, the 14th. Since we handled it today, can you strike that from the record or today? His docket notice said March 14th, and then Mr. Summers' docket notice said March 7th.
Oh, okay. Thank you. I kind of have to apologize for that. They were all indicated in the same pleadings, and it wasn't clear to me.
No, that's when that was the strike is on next week.
Okay, all right. Does either party have any, so I apologize for that. They were all presented sort of in one package. And I didn't separate those by the dates. Does either party have a problem with striking next week since both those issues have been resolved?
No objection, Your Honor. Always happy to get my Friday mornings back.
Okay.
That's fine.
You understand what's going on?
Yeah. I mean, this has been what's been happening through the whole dang court procedures. You know, I filed for a default judgment. Didn't get heard. They put it off, and then.
Hey, Mr. Bailey, I understand all that. I just want to clear the record that neither, since what was going to be addressed next week was addressed today, that everybody's clear that you don't have to be. And the next date forward for you folks should be a universal readiness docket, isn't that right?
Yeah.
That's correct, Your Honor.
Is there a date set for that?
Yes, that's currently set for March 18th.
March 18th. Okay. So, Mr. Bradley, you understand when you need to be back in court?
Yep.
Okay. All right. Well, then that concludes our matter for today.
Okay.
Thank you.